Rhodes, Ritenour.
I'm sorry.
That's quite all right, Mr. Chairman. Thanks for allowing me to participate in this hearing today. I just wanted to touch real briefly on the three legal issues that we highlighted in our comments and then take any questions from the panel about that. They've all three been touched on before, and I think brought up by you, Mr. Chairman. The first issue we highlighted was whether the Clean Air Act itself allows EPA to impose different requirements on individual states. Why does West Virginia have a 1620 pounds per megawatt hour, while Virginia has 810? And, you know, as John Daniel talked about when he was up here, one of our concerns is whether or not we're getting sufficient credit for the utility and ratepayer investments that we've already been making so effectively and so conscientiously here in Virginia over the last 10 years. The second highlight was this play between 111D as in dog and 111B. And this goes back to the fairness component that the panel has discussed. So 111B governs new facilities. And it actually has a less stringent requirement than 111D, which is obviously what's being used to govern existing facilities. And what I really mean by that is if you wanted to go out and buy and build a combined cycle gas facility, it could produce more than 810 pounds per kilowatt hour. But here we have a rule that we're supposed to be complying with by 2030 that says we have to stick within 810. So that's something we told the EPA during this comment period it should definitely take a look at to see if there needs to be more consistency between those two sections of the Act. I suppose what EPA would say is that the consistency would take care of itself in the greater regulation because you could have facilities, even if you have a new facility that comes online that's north of 810, you could have facilities in your portfolio, like a nuclear facility, for instance, that's well below 810, that would balance that out. But nonetheless, that's something EPA needs to look at this point. And then the third issue, which is something a lot of folks have touched on and perhaps is the most questionable, I believe, is whether or not EPA, under the Clean Air Act, actually has the power to, quote, govern outside the fence. Up until now, as far as we can tell, the EPA is focused on the facilities themselves inside the fence, requiring scrubbers, requiring new technology to be used to keep the carbon emissions down. Now we're obviously seeing from them a system-wide approach that goes well beyond the fence. You know, like I said, the Clean Air Act previously has just been used, as far as we can tell, to regulate the electric generating units, the EGUs themselves. And now we're looking at EPA taking a much broader approach. So when John answered your question about suits, I'll tell you this. In meeting with about a dozen stakeholders and figuring out what their concerns were, and looking at the law itself, and not to mention the fact that the rule, inherent in the rule, is a request from EPA to during this commentary period, tell it what we think the legal issues really are, which is what we've tried to do. And we know in their warehouse full of comments they've received, they're also giving a lot of other folks at least a level as high as the Virginia Attorney General telling them that there are potential legal issues with this. So we think now is the appropriate time to be trying to work with them to get them to work on and perhaps change some of these questionable legalities. And then when we're here, perhaps late summer, when we have a final rule, we certainly, the Office of the Attorney General, the working group we put together, will certainly be looking at that final rule with a fine-tooth comb to make sure that these issues have been addressed. And if they have or they have not, we'll be making another analysis at that time of what will be the appropriate response on behalf of Virginians, on behalf of consumers, to deal with the way the rule has been finally promulgated.
Yeah. Good. Sir, so right now you're saying that if the rules change slightly, if they stay the same or change slightly, the Attorney General hasn't even considered whether he would take action on behalf of Commonwealth Virginia against the EPA.
I'm sorry, Doug, I may have misspoken. What I said is, right now, excuse me, we have provided comments to the EPA, tell them to look at these legal issues, and we have decided right now that it will be premature to bring a suit. However,
but he has not considered at this point. You'll wait until the final rules.
Exactly.
So if the rules come out either very close or exactly as they are now, you haven't discussed whether that would be even at that point you're going to maybe think about
At
Why
that
do
point,
we on this?
because if this rule ends up being like any other rule that the EPA put out, and it changes dramatically between now and when it comes out, we feel like the proper thing to do is give it a wholesale review at that time to see what they've addressed, if anything, and take steps. And it's impossible for us now, we think, to know what that's gonna look like. So I think it would be premature, if not irresponsible, to speculate on what we may do when we see the final rule.
So it would be premature and irresponsible to say to the EPA, because as Mr. Daniel said, there were some strongly worded comments in here, and I see nothing strongly worded in this. In fact, I see really soft touches and just kind of end around approaches. There's nothing strong in this at all. Requesting with the EPA, there's nothing, no strong suggestions in here at all. I mean, it's really saying how, it's almost agreeing with them 100% in the first couple paragraphs, and then saying, however, if you wouldn't mind maybe please possibly considering a little bit of a change here, we'd really appreciate it. I mean, wouldn't it be a good idea to understand now and maybe have a message from the Attorney General's office right now that says if these don't change, yes, we will have to join some of these other states? As opposed to, well, let's wait and see, because right now, we're not going to really care until we find out what the final ruling is. I guess it just seems like we're not really. If I was the EPA, if I was the EPA, if I was with the EPA, I would just throw this in the recycle bin. Okay, whatever. Virginia, we're not worried about them. These other states are telling us, yeah, if this doesn't change, they're going to be on us, like white on rice.
Well, Doug,
but Virginia doesn't really care. Let's not worry about this.
Oh, Doug, I guess I would not agree with your characterization of us, what we've told EPA at this point. I mean, we really see this as a commentary period, a time to work with the EPA to try to straighten some of these things out. And it's impossible for us to know if they're going to take our advice or the advice of the other thousands of commenters. And a lot of times, in fact, I think most of the time, the rules look completely different on the other end. And I think it's only fair for us to say, these are the issues we have with however we worded them, these are the legal issues that we have, and the other 5 ways you can improve this rule. And if you don't, we're going to have to take a look at that time and figure out what we're going to do.
Yeah. So if I could try and narrow it down, then I'll get off my soapbox now. Let me narrow it back down to, so right now, the Attorney General's office has not even considered that if these rules don't change, that we will have to sue. It's not even in consideration until the final rule.
Our decision, I guess what I can agree with you on, Delegate, is our final decision on whether we sue the EPA over Rule 111D will not be made until we see the final rule.
So there's a possibility we will sue.
There's absolutely a possibility we will sue, but I'm not going to tell you that we will or we won't, because I think it would be premature and irresponsible. But I can tell you one thing for sure. When the final rule is promulgated later this summer, we're going to be going back over it to at least a greater degree as we have over this proposed rule to decide what we're going to do. And by the way, our Office of Consumer Counsel, which is in my division over at the OAG, really hopes to be involved with the SCC, the DEQ, you all, in figuring out what it is we're going to do going forward once the final rule comes into place.
So do you think if it does not change at all, that we will file suit?
I can't say. I do not know.
Might be. Have you looked at some of the lawsuits other states have filed at this point?
Yes, Senator. The main one is the one that was led by West Virginia and involves 12 states. And the main point they're arguing there is that there is what we call the Scrivener's Dilemma. That the gist is that there is a portion of 111D that in effect says if carbon is regulated in another federal statute, that it can't be regulated under 111D. And the background, very briefly, if I understand it, is when this portion of the code was passed by Congress, the Senate and the House obviously passed their own versions. They both voted on the other sides, and without knowing it, one version actually had the portion of the statute that I just referred to, that is, if it's regulated under another statute, you can't regulate it under 111D. And the other part of the statute, the other version did not have that in it. So the 12 states, the way I understand the lawsuit, are coming forward making that point. And as you might guess, rightly or wrongly, the EPA's response is that it's premature for you to be making that argument now because it's a moving target. It's merely a proposed rule. And the motion to dismiss is right on March the 3rd, and the DC Circuit which has thrown out a lot of these cases in the past because it's just not, there's no final rule. We'll have to decide on the EPA's motion to dismiss, and I assume they'll rule sometime in March. But I guess I would, to put a finer point on it, Senator, I didn't need to digress there. But we're currently with the other 38 states that have taken a look at this and have decided to play with the period we've been given to make comments as opposed to overtly or offensively suing at this point.
Yeah, let me ask you, now, I'm not being an attorney, I'm a little bit out of my league perhaps, but I mean, when they assign one rate of carbon output per megawatt hour, and I know it's addressed in the Attorney General's letter, to one state and a totally different one to another state, it seems to me that there's some equal protection under the law mechanism that would say, how can you arbitrarily assign numbers to different states? And I understand they're using a baseline of 2012, but I mean, that seems to be totally ridiculous and by using that baseline to come up with this, because, you know, I'm looking at West Virginia, who has filed a lawsuit, and all they got to do is basically direct Virginia, a huge generation plant for Virginia and Mount Storm, to shutter, put up a gas plant, and they're in compliance. At least that's the testimony we heard earlier today. Yet we're going to be forced into shuttering virtually every coal plant, building a very, very expensive nuclear power plant, and bringing on all kinds of Virginia ratepayers are going to be exposed to having to pay for the stranded costs for the coal plant shuts down, the cost of the new nuclear power plants, the cost of the new gas plants, and that interim, we may never get back up to that generating capacity in Virginia, and the need to have to buy off the grid for the remaining part of our power is really going to expose Virginia ratepayers, A, to an increase, and B, to a degree of uncertainty of the State Corporation Commission to even have the ability to regulate electric rates due to the amount of power we're buying off of the grid. I'm just concerned that issue of Virginia being singled out, and I will call it being singled out when I look at the neighboring states, to reach a threshold that will force our ratepayers to reach a number that you know, arguably somewhere between 20 and 30%. I've heard higher, I've heard lower, but it obviously depends on what 4 blocks and what combination of blocks is put together to try to reach this number. Very much concerned that Virginia does act on behalf of Virginia ratepayers, be they individuals, consumers, or business, regardless, to at least insist that we get fair treatment vis-a-vis the other states, and move forward. Very, very much concerns me.
Mr. Chairman?
Yeah.
I'm sorry, Mr. Chairman. It certainly concerns us as well, which is why it was the #1 legal issue we flagged for the EPA. And also in our list of 5 improvements, number 5 was promote more regional cooperation. And I can tell you that our working group is certainly attuned to this and concerned about it. The Attorney General very much is. I will certainly convey this panel's concern about it as well. I mean, it's evident that that's a concern. He knows the way you feel. And that's why when we commented the way we did, why were we looking at it, like I keep saying, with a fine-tooth comb once the final rule comes out. We think there's a disparity too that needs to be dealt with by the EPA.
Other questions? Okay.
Thank you, Mr. Chairman.